Welcome to Rules, Enactments, Intergovernmental Relations Committee. Please stand and be pledged. Legislator Elmer, please lead us.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Roll call.
Legislator Elner.
Here.
Legislator Nasarino.
Present.
Chairwoman Adenizio.
Present. Moving on to number 3 is acceptance of minutes. Do I have a second?
Second.
All in favor?
Aye.
Moving on to number 4 is the approval for the town of Kent, the ARPA funding. We have here dated March 19th, requesting that the ARPA and sales tax funding from the county be reallocated. The town determined that they'll need an additional $70,000 for the town hall renovation project, as costs have exceeded the original budget. The town would also like an additional $30,000 for improvements at Ryan's Field for the tennis, basketball, and pickleball courts. And finally, the food security project will be reduced by $100,000, as the town officials feel they will not be able to spend the full amount with a designated time frame. And just so everyone is aware that the $30,000 for Ryan's Field was presented to the county's ARPA consultant and was deemed ARPA compliant under the requirements. Any discussion? Would you like to speak on this?
Well said. But, no, again, this is a direct result of, having our town hall meeting, getting all the municipalities, on board, understanding the process, understanding the guidelines, and, everyone's now responsive. Mm-hmm. So I'm excited to keep this thing moving. Yes. I know they are. They're good projects. Like I said, back in, back in the March rules,
Right.
same process.
Mm-hmm. Right, so we're getting close to the deadline. So
Correct.
Do we have another year?
Well, we have until the end of this year to commit the funds.
Commit. Mm-hmm.
And then they have an additional 2 years to spend everything and get the project done.
Okay, thank you.
Yeah.
Anyone else? Any comments, questions? Legislator Goldman.
Thank you, Chairwoman. Not Kent, but all the towns basically doing the right thing and falling into place with this ARPA funding.
Yeah, so, you're gonna see, this is Kent, the next agenda item is gonna be Phillipstown, and then there's later on for other business, there's the town of Carmel. So pretty much at this point, we've almost hit every single municipality at this point. And the smaller villages, they're right on target, and they're doing what they were supposed to be doing, so.
Yeah, thanks for working with them, because it would be a shame if we were to lose that
Correct.
money.
Correct.
Legislator Nasreen.
I think it's a good thing because the towns have had time to reassess their needs and their priorities and have put forth repurposing the money. So it's to the benefit of the towns as they look and analyze and make sure that the money is going to more priority projects than had initially been purposed for.
Correct. And I would like to, on record, go on, commend obviously our ARPA consultant. She's been wonderful in her team. They're reaching out to all of the municipalities. Jen Caruso from our administration, she's doing a wonderful job. And I think Barbara's back there, and Barbara Barbosa, planning, she's been amazing also. So, this has been a real hands-on team effort.
Very good, thank you. Okay, make a motion to approve. Do I have a second?
Second.
All in favor?
Aye.
Moving on to 5 is the town of Phillipstown, sales tax funding change request. They're also asking for the funding to be reallocated. We approved $739,340 to be used for the Garrison Landing Water District project. And since this resolution, the town supervisor has requested the sales tax portion of $369,670 be reallocated to a different project that would include a new well and be able to expand their water source capacity, providing a better and greater benefit for the town.
Yeah.
Anything?
Jen, come up. Jen worked with the supervisor, Van Tassel, on this particular one. I'm going to let her speak a little bit more in detail.
On this one, they're just repurposing their sales tax. This is a slightly different project from their original project. Their ARPA funding is yet to be determined right now because they switched the project, but there's a question of its ARPA eligibility. But we've been working very diligently with them and the consultant to try to come up with a solution for them. So in the meantime, in order to make sure that they have something set, we decided to put forth just the sales tax portion, so they have that and they can use that for the project and continue to move on. I know they had a issue with their water source and it was a emergent need, and so we just wanted to get that buttoned up for them, so.
Very good, thank you. Any questions or comments from any other legislators? Anyone from the public? Okay, make a motion to approve?
Second.
Second? All in favor?
Aye.
Aye, thank you. Moving on to number 6 is a discussion regarding request from the Law Department to the Putnam County Clerk for records of the county that are maintained by the clerk's office. Do we have Michael Bartolotti? Yes, there you are. Our county clerk, thank you.
Hello, everyone.
Hello, good evening.
So, I don't know exactly what the nature of the request is that you're making of our office. I will tell you that any records maintained by the county clerk's office are open to public view. The majority of our records are actually available for view online, free of charge, unless they are sealed by law or court order. So if you could elaborate on what other records we're talking about, I'd be happy to shed some light on it.
Legislator Yonke, you had that request. Can you speak on this?
Yeah, we had a discussion with the county attorney regarding a case that's currently out there, and he was in Compton. And maybe you could I want to get through just wherever the roadblock is here. There were files from the district attorney's office that we were told you were not releasing.
Well, I just want to say.
Is that clear?
This came up in executive session, and we were talking about a specific case, and it was a file that we weren't able to get a hold of, and that's why it came up. I didn't put this on the agenda tonight. We were summoned over.
It's a process. This is a process.
Well, it's something that has to be addressed, probably with the charter. I don't know, Heather, if you want to pipe in, but probably with the charter. We've had some issues getting files quickly. Not a lot of files. We don't need a lot. The question that arose was, whose files are these? And I've always taken the position they're the county's files. And it's very difficult for us as county attorneys to discuss why we need files with department heads and with, in this case, elected officials. And we just saw that recently, and Heather, you may want to elaborate just a bit.
Yeah, just to clarify, basically what has happened is, and this is not just in this case, this is just broadly, we've had difficulty with department heads in getting files, and oftentimes they want an explanation. And we're not trying to be obstructive or secretive, but there's privileges and all sorts of confidentiality that arises from legal matters, and sometimes we're just not in a position where we can disclose why that is. In this particular instance, we had asked Mr. Bartolotti to disclose a file that was, to our knowledge, a district attorney file, and that we had previously had in a FOIL request. And we realized in going through the file for the FOIL request that it was pertinent to another matter and was necessary in order to respond to a discovery demand that we had in another matter. And we had, at Mr. Bartolotti's suggestion, requested the file from the district attorney's office directly, and the district attorney's office had indicated that they were unwilling to give it to us, absent an explanation of why we wanted it. And that's where we run into the problem. And so the question is, how do we fix that?
I think the crux of the conversation, the dialogue here tonight, and County Clerk Bartolotti, correct me if I'm wrong, is to establish where the guidelines are within the county clerk's office. In my opinion, the county clerk is the custodial of these files. I don't think that he has carte blanche approval from departments to just hand over files without their knowledge or consent.
Right, so if we're talking about a record that's housed in the county record center, which we're managing as the records management department for the county, we are not the legal custodian of that record.
Right.
It's the department that is the legal custodian of that record. We do not do anything with those records without the knowledge and consent of the department that created that record. That includes destruction, that includes transfer, that includes ascension to the archives. The only time under the law that I'm aware of, and that's state law and that's county code, that that department would lose legal custody of any record is if they ascend that record to the archives for archival purposes. We don't know what's in those records. There could be things that are sealed by operation of law and numerous other things, and there may be PII in those records. I will tell you, as a practical matter, we don't go through those records. We get boxes of records, we know what types of files are in there, we know the date ranges, but nothing gets done with those records without the knowledge and consent of the agency that oversees those records.
And as Mr. Spain indicated, that's what we need to discuss is whether, from a policy standpoint, there needs to be an amendment to the charter, because that's problematic. And here's why, is that the county attorney is responsible for representing all of the county agencies. And in order to do that, there's going to be times when there are legal matters that arise, sometimes internal to the county, sometimes from someone suing us from outside the county. And there's going to be things that it's appropriate for the department head to be made aware of, and there's going to be things that legally it's inappropriate for them to be made aware of. And so the county attorney has to have access to these files in order to represent the interests of the county in an ethical and appropriate way. And that is in no way to suggest that there's any mishandling of this, but we need to make sure that the county attorney has the power to do our job, basically.
The reason I asked for this to be on the agenda tonight is because I believe that the county attorney should have all the records that he needs in as quick a time period as he can get them. The county clerk is saying they're not his records. The district attorney is asking for a reason why. Is there anything that the county attorney can do? Does the county attorney owe the district attorney an explanation as to why he needs those files?
It's our position.
I'm asking the county clerk.
Sure.
You're asking me, what was the question?
Does the county attorney owe the district attorney an explanation as to why he needs those records?
I mean, as far as for my purposes, I would say that would be between the county attorney and the district attorney. I would caution that, you know, if we're talking about legal custody of a file, we don't know what's in those files. The county attorney's office may or may not know what's in those files. There may be things in there that are sealed by operation of law. I will give you an example. Okay, let's say for instance that the county clerk was not the records management officer, but the county clerk's matrimonial files were stored at records management. I would not care who made the request, because absent a court order under domestic relations law, the only people who can have access to matrimonial files are the parties, their attorneys of record, or the court itself. So if somebody else had an interest for whatever purpose may be, they cannot get in there absent court order. And there may be other records that fit that pedigree. So I would caution about giving any department access to another department's files without the knowledge and consent of that department.
I think that this would.
Whoa, we're not.
Through the chair,
We're
please.
a little different than a department. We're the law office for the county.
Yeah.
And, you know, we have ethical obligations, clear ethical obligations that we have to adhere to. And, you know, this particular matter that arose over a case that occurred 30 years ago that is of great consequence to the county that we're trying to zealously defend. I don't want to go into too much detail here in open, but I'll be glad to go in the other room and explain further if we want to have a discussion. But we're talking about highly sensitive matters very seldom. We're also talking about not only elected officials, we're talking about department heads. There's no reason why, and I used this example last time, that my office should be, for example, arguing with Mike Cunningham about something we need from the Office of the Aging, and he have control over it. likely this particular file that we're looking to see, this particular case goes back, former DAs, do we have to call Kevin Wright? Do we have to call Bob Thorbrand down in Florida? Do we have to call, they were originally, some of these characters were originally involved in these files. Or, that could theoretically be involved in these files. This particular file, it came to our attention only because there was a FOIL request regarding it, we reviewed it, and one of the attorneys in our office saw something that might be relevant to this matter at hand, which is of huge consequence. So, that's the issue.
And just to supplement one issue, is that this entire argument falls a little flat, because when we had requested this file for a FOIL, there was absolutely no problem giving us the file. So this file was in our possession already, and all we did was ask for it back, because we needed it for another matter, and now suddenly it's become a problem.
Well, I would like to say that I feel that this is unprecedented. We've never run into, in my 12 years, almost 12 years, of this need to circumvent another elected official or even a department head to access the file. I would not support a charter change to give total carte blanche ability for the law department to encroach on these files without the knowledge, consent, or permission from the department head. And even case in point would be a department head such as IT. There are very sensitive security measures that are available to our IT department that it's ethical as well, should not be accessed without their knowledge and permission. And that's what you're asking of us, that is exactly what you're asking, because if we wouldn't be having this conversation if the DA had given you permission or the DA gave consent. Obviously, he has not, and maybe we need to speak to him, but it's not even this case. It's not even the circumstance that's before us tonight. It's the procedure of the county clerk's department, and as even the legislature. We wouldn't want any other department infringing upon our files without our knowledge. That's really...
You have the knowledge, and it's not a fishing expedition. We can come
No,
before, we can come before you in any executive session and explain why we might need a certain file.
But you're running into a stone wall with the DA.
No,
So
no, actually, we did, Ms. Nasser.
Well, then there wouldn't be a problem if you weren't.
We asked the DA for the file, and we were asked to give information that would be ethically and legally inappropriate for us to give as a condition of turning over the file. And your concerns are absolutely well-founded, and we would never ever present a charter change that didn't address your concerns, because you're correct. There are other departments that have confidentiality issues. There are other factors that are going to, and we're not looking for carte blanche. Whatever we would do would absolutely take into consideration these important interests that you're raising. And I think that this is the important balance of things, is that in order for an attorney to do our job, all of these different departments are our clients. And one of the most important things you can do with your attorney is to have transparency, because we can't defend what we don't know. And that's what we're asking, is we're asking for the departments to cooperate in giving us the information that we need to defend them. This is not us being adverse to anyone in the county. This is us trying to protect the county and the district attorney's office and our county clerk in making sure that we promptly reply with discovery demands when we know something exists.
We understand that from your point of view through the chair, but from every other point of view, the county clerk's point of view and probably the DA's point of view, which I may take liberty to speak for, it is not okay. It is not a comfort to have him circumvent the DA to access a file for you, which was the initial request. I don't think it's okay for the DA, or if he asked for a rationale for your request and you found that unacceptable, then something's not.
This is not an active file, by the way. This is not an active file.
But
This
it's
is a
still
closed
under
file.
his
This is a closed
jurisdiction.
matter.
It's still
Yes.
under his jurisdiction.
Legislator Elner.
First of all, County Clerk Bartolotti, thank you for coming. I got a couple questions, so it's going to go a little bit around. One, My understanding is any file that is in your control, anyone can have it, correct?
No,
Not, we're talking, I believe in this
In
instance here.
general, any file that.
No.
No, not, we're talking about records management here, okay?
okay.
So basically, our records management department, our records management center, we have a cooperative records center, okay? We're one of the very few in New York State. So, and I'm glad that you brought this up, because it's a very valid point that I'd like to bring up with this as well. So we manage and store the records for all county departments, all 6 towns, all 3 villages, and we even have towns and villages outside of Putnam County that we manage the records for, okay? If there were any change or anything where there would be a possibility or a probability where another department could access a record that's housed in the record center without the knowledge and consent of the department that sent it to us for safekeeping, I could tell you that place would be empty tomorrow. I know I would move my records out of there tomorrow, because there is no way that I would have a situation where as an elected official who oversees these records, who's the legal custodian of these records, to have a scenario where somebody is going in these records without my knowledge and consent, that would be catastrophic. And the integrity of the records management for Putnam County, cooperative records management, will be thrown out the window. Those records are there because these departments have no room to store them in the 4 walls of their agency. That's what we're doing. And everything is done in ours, just like every other records management department, whether it be at state archives, all the way down to towns and villages throughout New York State. Those are the department's records that entrust them to us for management. And nothing is done without their knowledge and consent.
Now, the continuing of this, so we have advise and consent. Doesn't seem to be an issue regarding advise. What is the policy and the procedure if consent is not granted?
It would have to, the department who's the legal custodian would have to request a file from us. In other words, if there's a box of files that we have in the record center, I'm not giving that box of files, I'm not delivering it to anybody but the department that asks.
I'm saying specifically in this situation, someone's advised, consent has not been given. I'm taking this hypothetical.
Well, I would say that would have to be worked out by, if it's the county attorney's office requesting the file and the department that the request was made to.
So is there a policy, is there a procedure, is there something in the charter when consent is not granted? Does it come before the legislature, and do we make the determination?
Not that I'm aware of.
no.
Okay, so there is no formal procedure regarding if consent is denied,
Not that I'm aware of.
okay? And does it make a difference whether it's the original file or a duplicate of the file?
No, the file's the file, whether there's duplicates or...
I think this really challenges the integrity of the custodial files, and I really think it's a slippery slope that we're going on. And my question to you, Heather, is if it was easily obtained through a FOIL, then why can't you get it through a FOIL again?
Because it wasn't our FOIL, it was us responding to a FOIL on behalf of the county. So all we did was exactly what we tried to do here. We had no anticipation that this was going to even be an issue. Every time we've requested a file, Mr. Martellotti has always supplied it. We've never had an issue with the county office with respect to that. To my knowledge,
If you asked for a DA's file, you wouldn't get it from me, you'd get it from the DA.
this particular file had been archived, so that's why we had gotten it from you. It was an old file.
If it was archived, then it would be a public record. If it's not archived,
But that's-
it's the property of the district
And it
attorney's office.
should have been a public record, is what our whole position has been. But neither here nor there, just answering Legislator Nassarino's question, is that which actually, could you repeat your question? I'm sorry, I know I've lost my train of thought.
Why couldn't you just FOIL for it if
Yeah,
it's
because it wasn't, in order to, FOIL has all sorts of restrictions as to what we would get or what we wouldn't get and whether it's there. So we didn't obtain it by our FOIL, we obtained it to answer a public member's FOIL. And in addition to that, just to give an example of like another circumstance to take it outside the context of this, which is, got its own underpinnings, is that A perfect example of a circumstance where it wouldn't be appropriate to notify a department head is that if we had a lawsuit or allegation that involved, let's say, malfeasance of that department head. Let's say that department head was accused of sexual harassment or something, and that there is a victim within the county who we would have to protect with respect to, respecting their identity and everything else. Sensitive matters like that, sometimes we would require internal files, but it wouldn't necessarily be appropriate to notify the person who is the target of the lawsuit until we had an opportunity to investigate what the records of things are. And this is not to impugn anyone, but in circumstances like that, sometimes people do try to take retrospective analysis. They try to talk to their staff or try to cover themselves with things like that. So I guess the point is that there's all manner of legal issues that our office confronts, and not in every circumstance is this normal protocol of things, notifying the various offices going to be feasible for legal reasons. And that's just one example.
But you
But
just
that's
can't
easily
take those.
resolved with a petition to the
Right.
court. We get requests often where an investigatory agency might not want the individual to know that a particular document has been requested or a file has been requested. You get a court order or a subpoena, and it's easily resolved.
Exactly, and in this particular instance, if we were to do an application to the court, it would be incredibly negative and embarrassing, and with pending litigation could harm the county's interest. And that's why we sought to deal with this internally. Ultimately, we can make application to the court, it just wouldn't be necessarily in the county's best interest to do so.
This is a very limited set of circumstances here. We're not over there mining files all the time and looking for files. It's just, this particular case has brought it to our attention, and it has been, some of the files have been slow walked, according to some of my staff, in the past.
But I think we understand that, but we're not just looking at the case in point here, we're looking at setting a protocol that needs to be respected, that needs to protect the privacy and integrity of each department's files, and not have the ability to circumstance.
Yeah, but I understand if a department head is looking for, if Mike Lewis is looking for a file, but I'm talking about the county attorney's office.
But
We're representing on litigation and sensitive matters. We differ, you say someone or someone. I'm talking specifically about the county attorney's office. We represent the
the
county.
county attorney's office never had those liberties
Because they've never done what
before.
we're trying to do over there.
Well,
Most
but
respectfully,
we
they've never done, we're looking at every piece of litigation, everything the county's involved with, everything that outside counsel is doing, we're reviewing. It was never done before. We're looking over NYMER's shoulders on these cases. I've expressed that to all of you. We're trying to do the best job we possibly can. We're not just accepting what outside counsel says, we're not accepting what NYMER does. And I can go into much greater detail relative to CREVAC, which makes me very concerned, which I've expressed to all of you before. But if your policy is this, it's your policy. But it's hamstringing us in trying to do our job, and theoretically, it hamstrings us going forward. And as Heather said, I think it could very easily be handled if it was set forth clearly as to, that we have to actually sign out a file. You can always call us into executive session to say, why do you need this file?
We
But
can
the thought
request
of
your
us,
authorization
the
before
thought of
being able to-
us as county attorneys having to have a dialogue and discuss and go back and forth with department heads, most respectfully, is preposterous.
Well,
But
I
my-
wouldn't agree with that.
My goal here tonight is to try to make your life easier, okay? And you should have these records. I'll ask the county clerk, is there anything about our policy that doesn't conform with state law?
No.
It conforms with state law.
No.
So this is something that other counties probably have. an
I've
issue
checked with numerous colleagues throughout the state, as well as the state archives themselves.
If you've explained to the district attorney that you have for ethical reasons, you can't give them a reason behind why you need the file, what's his response to that?
Well, part of the problem is, if you do that, I'm not relating to this particular matter with Bob Tendy or anything else, but there's just a chance that the file is going to be gone through very closely, very thoroughly, and possibly things could be removed, or things that we're looking for, and that's part of my concern. And that's my concern with this case as well, that the document that we're looking for could be removed. I don't want to accuse anybody of doing that, but there's a possibility of that. Somebody could go through the file very closely and say, hey, this is something, that maybe we should remove.
I think there's a trust issue there too, but
It
I
doesn't even
still
have to
can't
be.
support, I still think that we need to protect the custodial oversight that the county clerk has, and the protocol that we have in place needs to be held with integrity. The district attorney in this case is an elected official, and to encroach upon his files without his knowledge or consent just seems to be an unethical way for us to conduct business. I understand, you've said it many times, I get the point of the nature of this particular case, but we're setting precedent here when we start to blur the lines of who could do what and when. And I personally cannot and will not support that.
The issue is that it's a closed file, and it was an archived file, and it was just removed
It was
from-
not in our archives.
We were told it was from
No,
archive.
absolutely not. And it would have been
I have an
delivered-
email from the district attorney's office saying it has to be returned from archive. So the district attorney's office believes it to
I
be
can
an
assure
archive.
you, as a records management officer, that file is not in our archive room.
Well, what was represented to us in writing by the district attorney's office
Well,
was
they were
that it was an
incorrect,
archive.
because they're not the records management
I think that
officer.
you would have to settle this with the district attorney.
I would just add, I think these files.
Excuse me, I have the floor. Thank you. There's a couple other issues. One, we're talking about the integrity of the file. There has to be a mechanism, because this file obviously is not in the district attorney's office's possession, correct?
Correct.
So whenever the file is recovered, the county clerk's office can go there and supervise and make sure that there's no tampering done with the file and all the information which you're looking for gets there. The second thing, through the chair, is if I may, do we have the authority to have a legislative subpoena and force and compel that the file be turned over to the requested and needed parties?
Through the chair, I'm glad you asked that, because that's what I've been thinking of. Yes, there is a provision that allows the legislature to both conduct investigations and to issue subpoenas. It's not something, I had previously researched it, and it's sort of a gray area. There's not a lot of case law on legislative subpoenas, but our charter does give that power to the legislature. So it was something that would need to be fleshed out, but in theory, the legislature, the law department could come to the legislature and say that we're not getting cooperation in the production of a county document, as long as it's not something that's under seal from a court order, which I think would trump a legislative subpoena, or protected by statute, like County Clerk Bartolotti was saying. In theory, under this legislative subpoena power, the legislature could order even an elected official to turn over a record because they are it's county property.
That was my position, it's county property. It's not Kevin Wright's, it's not, Kevin McConville. I certainly recognize there's gotta be something done relative to active files. We're not looking for active, and I certainly wouldn't ask Kevin McConville or Bob Pendy for an active criminal file. I've had discussions with both of them on pending criminal matters that have influenced the county. I've met with both of them on certain issues, and they've explained, and I've explained our position, that's fine. And we're certainly not soliciting active files. These are closed files, and this particular litigation we're talking about spans 30 years.
Mr. Chair, I would like to have you send a letter to the district attorney requesting some rationale as to why he would not release these records. I think that the missing link here is having the input from the county attorney before we go subpoenaing or doing anything so drastic as that. I think that's really an outreach for us to start doing that. And we really, in all fairness to the district attorney, haven't heard why he's so reluctant, but he might have some very valid reasons. So we're hearing one side, we're not hearing both sides, and I think we should, even if it's a confidential memo that he sends back to us, I'd like to hear from him.
I don't want to make a mountain out of a molehill with this.
No, we
And-
won't,
and
no.
there's other ways, I can solve this particular issue, quite frankly, that I've already, thought through. I don't want to create an issue with Bob Bob and I have a nice relationship, a good working relationship. I would just soon let it die. I didn't bring this in here, Mike. I
No.
didn't call and say, let's go up here. You and I have had 4 or 5 discussions. We've respectfully disagreed. I don't agree with your position. You don't agree with mine. We've had a nice relationship about it. But as far as I'm concerned, it's fine. Let's let it go. I don't want to make this a huge issue. We can do our job. Some of the files have been slow walked. I haven't gotten involved where I've been arguing with the department head over something to date. If something does come up, Rob's made a great suggestion. You can always come here, but let's let this thing go. All right? I don't think it merits
That's fine. That's
bringing
fine.
everybody in and causing a big brouhaha.
I
I'm only
right.
discussing this because I was asked to come here to
Right,
say
we
this.
understand.
Well, I want you to have the files.
Well,
And I want the integrity of the file preserved.
it's, you know, I mean,
No.
there's another way I can handle this. Okay, very clearly, what an attorney in our office saw in that file, there's another way for me to get the information.
Okay.
So I'm satisfied with that. I don't want to come in here and argue with everyone about it.
But if there's no change, then moving forward, it's gonna remain the same. just
Well,
so
if
that way
he
that's-
needs something and something comes up, I'll follow Rob's suggestion, we'll reach out to Rob and we'll pursue it that way. To date, I'm not looking to look at every single file.
Right. No,
And
I
I'll tell you something, I'd be more than happy to go in executive session if it ever does come up and say, Mr. Spain, why did you want this file? And I'll explain to you. But I'm not looking to go on a fishing expedition or looking at anybody else's business. Just things are constantly coming in to the office, and it does require us occasionally to have files.
I agree, and thank you for that, because I just think, I feel very strongly about protecting the integrity of the county clerk's office. I also feel very strongly that any decision that we've made that would circumvent any of the procedures that are in place and the integrity of the department will have ramifications. So we're not just basing our position on one case. What we do, or what, if we alternate from what we do, and will have ramifications in how things are done in the future as well. So we really have to safeguard the integrity of records management, and that's my concern. It's not just this one case, this one issue, but it's a slippery slope to go down, and I would like to see it stay intact. I would not support anything but having it remain as is.
I would just reiterate one more time, we're a little different entity than everybody else. If Mike Cunningham, for example, I'm using Mike, or Nicholas is looking for a file, I understand, that's a whole different. We're the county attorneys, we're representing everybody, and that's what I've tried to impart in everybody in my office. You're our clients, and we try to respond quickly to our clients. Everything we try to do is quickly and correct, and, you know, that's the way we've operated, but we're the county attorneys. When you say someone, you know, it's just a little bit different, you're mixing apples and banana bread to me. And, you
I don't
know,
think
so
so,
I
right?
feel strongly, plus I would just say, we have ethical obligations. I mean, you can file an ethical complaint against me, I'll be dragged down to White Plains in about 5 minutes. Rob can educate you on that, you know? And I'm not looking to do anything untoward. I'm looking to try to represent the county as best I possibly can, as aggressively as I can.
And I think everybody in this room is trying to do the same thing.
Yeah, well, it just,
Including
no, but
the county clerk.
you're just mixing me with another department head looking for records. And that, I just see a gross difference in that.
Well, we'll agree to disagree, I think.
All right, that's everyone good? Okay. Anyone from the public? Yes, please come up and state your name.
Yes, hi, Lynn Eckhart, Town of Southeast. Just a quick question, which is actually Mike could answer for me, I think. I was concerned when you talked about possibly tampering with files, and this isn't in regards to this particular file. How much is digitized, and wouldn't that really help solve that problem?
Yes, a great deal of our records are digitized. We're working, we actually, I would say since 2015 forward, we've gotten probably about 600 grand worth of grant money to digitize. We digitize all day, every day, and yes, that absolutely protects the integrity. I will tell you, you know, we have great security monitoring in our facility. It's alarmed, it's cameraed. Many of the boxes, especially boxes which may have sensitive information on it, are taped. They're taped up, they're physically taped. When they come to us, they're on the shelves. We don't know, in other words, we don't exactly know what's in the files. We know that these files contain certain records from a certain time period in a tape box, and they sit on the shelves, and we don't touch them because they're not our records. We're just managing them.
Thank you.
So, in regards to that, I have a question. With the box is taped and then somebody signs it out, how do we know that you're getting the records back intact as they were? They're not digitized at that time when they're signed out. How is that secured?
So again, the record belongs to the agency that signs them out. We have a designee, and that's exactly the point. We do not allow other county departments to sign out the records of another county department, regardless of the department, unless there's other superior authority demanding that we do so, like a court order. So if somebody wanted a record, it would be the designee from that particular department to get the box of their records. It is their record, and it's in their possession, and if there's malfeasance, then there's malfeasance. I mean,
So there isn't any like provisions put in place to stop it from, like a document from disappearing that's an inactive file?
If it's not digitized, if the only copy is the hard copy, then no, but that you could apply that argument to a file that's sitting in their office.
No, I'm just wondering how that works, because moving forward, maybe that should be something we could look at for safeguards, to make sure it is digitized, to make sure we have the full copy on file, and it's.
But they have the ownership of those files.
I understand they're the ownership of it too, but once I think it's turned over to the management records, I mean, and let's say another entity signs it out, they allow it, what's stopping someone from messing with that file and then returning it, even though they've been allowed to take it?
Right.
Is what I'm saying.
But only the department is allowed
Only
to
the
take it.
department.
The department is allowed to, or gives permission to another department,
No.
right?
No,
As-
no.
Just the designee.
No.
But with your FOIL requests, you guys get copies all the time. So at any point, if that file that they received, right, could be, and I'm not saying this, I'm just using it as an example, it could be moved around where paper could get lost by accident, and I'm just saying maybe it should be a good idea to have a safeguard in place when it's signed out, because they do answer FOIL requests all the time, as a backup.
Through the chair, but only the department gets to handle those papers.
So, but it could be somebody within the department, you're saying also.
Yes,
That's right.
but I'm trying to point out like a FOIL, sorry, through the chair, but through the FOIL request, they often request to fulfill FOIL obligations, correct?
Yes.
If the county attorney's office is working on a FOIL request, they would work with the department. They would not directly contact records management on behalf of the department to get the record. No. The department would have to
The
provide
department is supposed to go through the file, send us any questions they have, and then we'll come back up. That's the way we tried to make it evolve. I would just say the question is, whose files are these? Okay, I don't agree with you that these files belong to anybody other than the county. I think they're county files. I'll also say this, there should be some kind of provision that mandates the protection of these files. And we've seen here with CREVAC, we're going back 30 years, these files should have to be maintained. They should be, when they're closed, they should be turned over to the county clerk's office. They shouldn't decide what gets destroyed, what gets held on, et cetera, et cetera.
With all due respect,
Every file.
they don't. So,
But they have the option to do it, as I understand it.
so
They
with
don't have to
respect
do-
to district attorney records, you would have to apply to the appellate division to get permission to have those destroyed. Any other record, we follow the records retention schedule, the LGS 1. Those files do not get destroyed unless the records management department feels that they've met their useful life under the retention schedule, and it's done in conjunction and with the approval of RMO and the department head to destroy those files.
Shouldn't it be in the charter, though? Shouldn't it be crystal clear?
Yes,
Shouldn't
it
every
is.
I'm not sure.
It's in 90.
Okay, it should be crystal clear that every file should be maintained and then eventually archived.
Absolutely.
Every single thing.
The only files that would get archived are files that have so, with apologies, a lot of people say archives, but when you come into the records management world, records management and archives are two very different things. In our record center, which is the size of this table, we have an archive room that's the size of this microphone stand, okay? And those are the files or artifacts that are considered to have historical significance for the county of Putnam. They are approved. The department actually releases those records to the archives to be held in the archives. They've reached past their useful life. They're actually public records, and they can be accessed by the public, and they're in the archive room. Everything outside of that archive room is something that we're managing for other towns or county departments or what have you. Those records are there. They're in boxes, they're maintained, there's security monitoring, there's flood monitoring, there's fire monitoring, it's maintained, and it's, overseen, it's housed by the Records Management Department. Once those records reach their useful life, as long as the department head agrees and the Records Management Officer agrees, those files are destroyed.
Well, I'm jumping track here, but just real quickly. So a department head might be able to decide what goes in that file that eventually heads to you. And I think it should be mandated that every single paper, every single document, everything must be sent over. And I would.
Well, I would agree with you on that.
Well, I don't think it's crystal clear in that, but I would also just say, these are county records. They're not Bob Kennedy's, they're not Mike Cunningham's, they're not Mike Bruce, they're county records. They belong to the taxpayers, they belong to everybody. So this idea that they're my records, I can do what I want with them, again, I don't want to be obnoxious, it's preposterous.
Well, do we know, Mike, do you know as far as other counties, how they move forward? Westchester, Dutchess, are they the same as?
We asked for a decision
Same
from
thing.
the Attorney General, by the way, and she just said, oh, it's a county matter. I mean, that's.
But the other counties aren't.
It took 3 months, we wrote to the
Right.
Attorney General, we got
It
a
is
one
a-
paragraph response
Right.
from.
But it is up to the county, but that would have to be a charter change.
Well,
And,
I just, hey,
you know,
I'm not looking
that's-
for you to do what I want, I just think it should be
No,
clearly
I'm just
stated in
saying-
the charter. I
No,
think
but what
the
I'm-
charter's gotta be clear.
But what I'm saying is, if they're doing what we're doing in the other counties, and there's no issue,
As
That's the
far
big
as I
question.
know,
That's the big question.
I
I would
checked
like
with
to
about
check
a half
into
a
that.
dozen
Right.
counties, and I checked with the state.
Again, it's a very isolated situation, and most times if I were to call Mike Lewis, he'd send it right over, say, come on over, let's go through it. I mean, this isn't a broad problem. It just happened to, it happened
understand.
It
to
is.
sprout up with
Right,
this,
I
with this
understand.
particular
Right,
case,
right.
which is very, very emotional.
Yeah.
There's a lot of people involved here. I've had them call my office, when papers were served, I mean,
But
it's
it
a
doesn't
very,
warrant a charter change, but I think we can,
Well,
like you said, there's
whatever.
another avenue that we can.
Whatever.
Yeah, okay.
This is unprecedented, and that's why we're discussing
Just
this
discussing,
tonight. This has
yeah.
never come before us, but I still maintain that I don't think that the administration would appreciate if the legislature just grabbed all their files, or the administration went down and grabbed the sheriff's files, or the administration, the legislature went into and picked the IT files. I think that it just cannot, I think that's unacceptable, and I could never support anything like that. It's just not how the ground rule should be.
it should
So
be
I would
very,
not-
it should be very restricted. It should be very restricted, and there's
It
no
is very
fishing expedition
restricted.
where I'm casting a rod down to the sheriff's
County
department,
clerk
reeling stuff
Bertolotti
in. This
does
is.
a great job managing our records management with integrity and privacy and protection.
Nobody's
to the
impugning him.
departments.
Nobody's impugning him. Nobody's saying he's not doing
But
his
the
job.
procedures that are in place for a reason. And we can't just have interchangeable people going into other departments' files because it's all county property.
Talking about the county attorney, we're not talking about anybody else. We're very
Well,
limited here.
you're still a department within the county.
No, I think you're talking over here, and I'm
No,
over
you're
here.
still a department within the county, so you have to adhere to the same charter rules that we all have to abide by.
Legislator Crowley?
I'm just having a hard time, I guess, understanding with the ethical obligations that we have to answering certain things on this case that can be very costly to us, why this document is such an issue and why it's taken so long. Like, what is the reasoning? If, like you said, Legislator
know.
Nasarino, it's unprecedented. This has never happened before. It's a little concerning to me to think that this is the first time it's happening. What is causing it to happen? Why is this happening?
Well, we should
And
write
it's
to the
bothersome, and
district
why
attorney.
isn't DA Tendy here to also
But we didn't invite him. We didn't
Well,
invite
he
him, just for discussion.
Right, but I mean, he is also part of kind of the triangle, that was involved in the discussion, and it's bothersome to me to think that this file, which they had, in their possession at one point, now has become this ridiculous, unobtainable, treasure chest, and I can't, for the love of God, understand why it's become such an issue, because we are talking about the county attorney and the district attorney,
Right.
and a very large case that's
Which is why
substantial.
we should write a memo to
Then
the district
we're
attorney.
going down the path of us having to talk about what we're doing over there. which has ethical implications.
That's what I'm saying, yes.
And effectiveness implications, you know? And that's where we're headed, where we're having to discuss with certain people that we shouldn't be discussing intimate details, and also, we're reviewing, we're analyzing, we're looking over, we're not sure, we don't have all the answers. And maybe this particular file doesn't have what we were told it has in it. And it's not gonna make or break the case, but they're looking for $50 million. So we're trying to do every single thing we can to protect the county and limit the amount of money that we're gonna pay.
I agree.
That's all we're trying to do. And I'm not interested in anything down there in the sheriff's department or in the DA's office, other than what it relates to exactly what I'm doing. Other than that, I don't really care. And if I did, file an ethics complaint against me or
I'm not
fire me.
saying you are, I'm saying it has a trickle-down effect and has ramifications if we overstep. That's what I'm saying.
No, differentiate
And I
between
think
the county
we need to hear
attorney,
from
the
DA.
county attorney, and everyone else. There should
We
be
need to hear from the
differentiation.
DA.
We can send it confidential,
No, listen, I really don't want to go down. That's a slippery slope. I don't want to go down. I don't want to argue with Bob. Bob and I have a nice relationship, and it's healthy for the county that Bob and I have a healthy relationship. And it's healthy for the county that I have a good relationship with Kevin McConville. I don't want to sit here and argue about this. Okay, I really don't. I don't think it's in the best interest of anyone to argue about this particular matter at this juncture. Okay, I was called up here to talk about it. You know my thoughts. I think it's county property. I think the county attorney differs from everyone else, every other department head, and that's my position. I made it crystal clear probably 10 times.
Okay, thank you, thank you. Okay?
One
Yes.
question, how time sensitive?
We have discovery demands pending, but there's been new counsel brought in for each of the respective parties. As the legislature knows, I recommended, and so that will give us a little bit of wiggle room because the court is going to give the new attorneys time to catch up. So it has given us some time, which is why we haven't taken drastic action seeking a legislative subpoena, and we knew that this was pending on the agenda. We figured we'd have the opportunity to discuss the matter with you. Obviously, as time drags on, it's going to become more and more urgent. And respectfully, as part of attorneys for the county, of which the district attorney's office is a part, this request is made in the interest of everyone, including the district attorney's office, because the alternative would be to give an affidavit from the county attorney staff member who viewed this, summarizing the content and having to disclose that we are unable to give the actual file over because it was obstructed in our ability to receive it from the department head and our own clerk's office. And despite seeking legislative intervention, we were unable to get it, which would be obviously pretty bad. And so we're trying to act in everyone's best interest in being able to say, this attorney accurately represented this or didn't, and we saw what it is, and it does respond to the subpoena, or maybe it doesn't. Maybe it's not responsive when we look at it. But without the actual document, we can't know. And so we're coming here in everyone's interest.
I want to just clarify one thing because we talked about the possibility. It doesn't matter, which we've researched, it doesn't matter anymore if someone was malicious or intentional on CREVAC or what anybody did. The county's responsible. We were thinking that quite possibly when we started that, you know, if there were bad actors or bad players or malicious actions done by others, whether it's down there, you know, down there or wherever, that we may be able to skirt some responsibility or liability. We found out we can't. It doesn't matter. If someone purposely did something and maliciously did something in CREVAC, we're responsible. So the only two issues that come up with CREVAC is one, how much we're gonna pay and who's gonna pay. And we're on top of those two things, doing the best we can. We're trying to suppress the amount that the county pays, and the only way that happens is to work with, you know, and CREVAC has some responsibility here, number one, and number two, obviously we have NYMER we're dealing with. So, I mean, that's where the focus is. I think we discussed in an executive session last time that, you know, there might be bad actors in some capacity here. It doesn't matter anymore. So just want you to know, relative to this file, we're not looking to, you know, attack anybody or accuse anybody or shift blame on anybody.
Not at all.
Because our research has found it doesn't matter.
Okay, thank you. Thank you for coming.
Thank you.
Okay. Don't leave, Heather. We need you up there. So moving on to.
Who's that?
Huh?
Thank you, Michael.
Mike, thank you.
Michael.
Thank you for
Thank you,
coming
Michael.
tonight.
This is just Just a question for the law department. As the law department's not, my understanding is law
Can
department's
you just
not-
say, could you state your name, just so, because we hear you talking, just.
Jennifer Caruso.
No, I
Yeah.
know, but Jennifer Caruso,
It's
thank
Jennifer
you.
Caruso
Mhm.
from the county executive's office. Just a question for the law department. As the county's legal representation, don't you have an ethical obligation to meet the discovery demand that's being put upon you?
Yes, we do.
So that's different than another department, I think, right?
Yes, that's exactly it. We have the ethical demands upon us, and the ethical rules upon us that we're responsible as attorneys. Separate and apart from working for the county or any other county office, we are bound by those ethical responsibilities and obligations, and therefore, we are held to a standard separate and apart from this. We could be ethically grieved if we don't follow these ethical rules and things and that is a safeguard to ensure that we're not going to engage in some sort of fishing expedition or something like that. If there was even a mere allegation of that, we could be grieved, and it could be investigated by the appellate division's grievance committee.
Just begs the question why the DA feels adamant about not releasing these files. So
I don't
that's
I don't think he feels adamant. I don't know what he feels. He just wants to know what's going on.
So why can't you just tell him?
Because it would be ethically.
Well, you could tell them in a way where you're not compromising
What we
the
did, what we
case.
said was it's responsive to a discovery demand. And that's what it is, that's what we told you, that's what we
Right.
explained, it's responsive to a discovery demand. Going beyond that would be inappropriate, and unfortunately for them, they want to know the details, and I understand why. This is litigation that bears on, them, that they're being accused of something, and I can certainly understand the impetus to want that, it's just we're not in a position to do that. But there is nothing untoward, and we're not out to get anyone, it's
We
just
know
we're
that,
trying
of
to
course not.
mitigate this. As Compton said, okay, because the district attorney is a policy maker in light of the law, they look at it that way, we're gonna be on the hook regardless. The question is, how much? And what we've realized is that this document that is responsive to a discovery demand was misplaced, okay? Probably inadvertently, probably just a filing error, but it was misplaced. And if we don't turn it over promptly and explain that this happened, they may impute some sort of malfeasance to it that would drive the value of this case up. And we're trying to avoid that. That's it. It's nothing more than that. And I don't know why we're not getting cooperation. I couldn't fathom a guess.
I think we're going to continue to send a memo because it begs the question whether or not there must be some valid reasons why the DA responded the way he did.
It's human nature, that's what it is. It's just human nature.
Well, I think it's in the
They're just
best interest.
curious as to what's
What
going
you're
on.
saying,
They
it's
don't
in-
understand it. This is a huge case. There's a lot going on here.
Well-
And they're everyone who's involved in this is very insecure.
We can't speak
And
for
rightly
him
so,
tonight.
'cause
We
it-
can't speak
it-
for him tonight.
Pardon me?
We can't speak for him
Well-
tonight, and we haven't reached out to him.
Well, the only thing is, I'm not gonna come up here and explain what we're up to.
No, we're
No,
not
no,
asking you
okay,
to do
I just
that.
can't- I can't do that. I'm
No,
not gonna do that
absolutely
with
not.
any
It just
department
seems-
head. I'm not gonna argue legal theory, discuss what we're looking for, explain what, we're discussing over in my office, because I don't think it's proper.
You just want the county's records.
I want the county's records that will help me help the county and defend the county. That's all I want. All I want to do is do a good job. And if I don't, turn on the lights and ask me, what are you doing? And I'll be glad to justify anything that I do. And everything that I do, I'm going to say this to you, everything I do, all I think about is the Attorney General coming down to my office and asking me questions. And I saw what they did over at Carmel High School with the sheriff that we were involved in, and it's just, I want to do the right thing. I never, ever want to do anything that's not defendable. And that's all we're trying to do. And we're, again, for the 100th time, we're just trying to do a good job. I don't think the county's ever had oversight like we've tried to impart on CREVAC and some of these other matters.
Okay, thank you.
Thank you.
Moving on to number 7 is,
Number 2.
no, 7.
All right.
Yeah. This is also a discussion on, we're going to talk about policy and procedure. I was asked to bring this up this evening for discussion. This is Putnam County versus Buccinas litigation. And I just would like to refer to a reporting timeline on this. On June 2nd, 2023, was the first entry of Vuccinis versus Putnam. Then we have 7 dates from, we have 7/12/23, 9/13/2023, 11/2/2023, and 12/6/2023, where the Law Department provides the legislature with a legal file list, and there were no entries for this particular case on those 4 dates. On December 13, 2023, their outside counsel was appointed by the county attorney, and Vuccinis was sued for a declaratory judgment, and we didn't know about that. Moving on to, we have 3 more dates that the Law Department provided legal file list again to the legislature with no entry for this particular case. And that was on February 15th, 2024, March 15th, 2024, and April 3rd, 2024. So to summarize, we received 7 files, lists, legislative file list with no entries for this case. So I have a question. We have a question on, policy and procedure here this evening. Legislator Yonke, and you asked, would you like to speak on this?
I brought this forward. You brought the timeline
Yes.
from then to now. For me, it works from now going backwards. On May 6th, we got a copy of a decision from Judge Capone about an action that was started by the county against an individual, all right? And
Just to stop you for a minute, it wasn't an action, it was a special proceeding, and I know that probably sounds interchangeable, but I
Okay.
just want to bring it up because it is a distinction.
Oh, it is an action. It was a declaratory judgment action, which is an action.
It's a special proceeding. You can look, it was brought by special proceeding.
I realize that, but it's a hybrid proceeding because you sought both injunction and declaratory judgment, and any declaratory judgment is an action. And Justice Capone referred to it as a special proceeding, I agree. But it is a proceeding, it's litigation.
I understand. I'm not saying it isn't, I just was making that distinction, because that's how we brought it, was by special proceeding.
I'm not the lawyer, so.
No, and
forgive me
I
if
didn't mean
get
to.
the
I just
words-
wanted
if
to
I
make
get
the
words
record
wrong.
clear.
But we got a decision on a proceeding, an action,
Yes.
a lawsuit, whatever you want to call it, that we didn't know existed. Okay, that we had no way to know it existed because it wasn't on any of the litigation reports that we got from December when this filing occurred until now. And prior to that, I know that this person, I know this is a nothing, to me, it seems like it's a nothing case, but it's the process of, this person filed a notice of claim back in, I believe, April of 2023.
May 1st.
It was May 1st.
May of 2023. There was a 50H hearing that occurred.
July 16th.
But it was never in any of the litigation reports. And number one, I have an issue or a question as to whether or not the law department can just bring an action. I always thought that you had to go through the legislature for approval to, whether it's an action proceeding or a law. I'm not the lawyer again. I have an issue with that, or a question about that, and I have an issue with the fact that it's not on any of the litigation reports. And I want to know, how do we know what we don't know? What else is occurring out there that's not on the litigation reports that we should be knowing about?
That's totally a reasonable question, and as far as the reports, I cannot speak to the reports. Compton would have to speak to the reports, because I don't prepare those. So I can't speak to that. What I can say is that it was, I took this case over from Connor, who you know has left, and to my knowledge, he had been in contact with Mr. Fiorello with respect to this and was trying to brief him on this, and was told something along the lines of that, he didn't need to be involved in the blow-by-blow with that. With respect to, that's just the first part in terms of the reporting. The second part of your question was, do you need to seek approval? And as you know, my colleague Conrad was here at the last session that I appeared at, and had suggested that we go through and perhaps audit the county charter, just take a look at things. And 11.2, which is the section in the county charter that references what you're saying, seeking legislative approval, is I think one of those sections that we probably should take a look at in terms of audit. And the reason is for 2 reasons. One is that as it's drafted, it's circular and kind of cancels each other out, because it says the county attorney is supposed to seek approval of the legislature or any officer with capacity to, grant approval, except that if there's an officer with statutory authority granted that empowers them. Well, the county attorney under County Law 501 is an officer with statutory authority to defend or prosecute cases on behalf of the county. So the way it's drafted, it's circular. That said, we did seek approval. We sought approval from an officer with authority, which was the county executive in this matter. We did that because there was a potential conflict in this matter that would have placed the legislature in a position of taking a position for or against a colleague's family member. And so rather than put the county legislature in that position, we sought approval from the county executive, who has authority under the statute to act.
So then the legislature had no right to know that this action
Well,
was being
hold on.
filed?
Paul, I sat right here. You were here, Rob was here, John Cherico was here, and Kevin Byrne was here. And we brought it up, and we were told, we don't want to discuss that. But let me just say, there's no matter that has been in my office that I have spent more time on than this case. Nothing. There's nothing. None of these, not CREVAC, nothing else. I've spent so much time on this particular case. I don't know if you want me to go through everything that went on.
It seems to me like it's a nothing case.
It is a nothing case.
It should be nothing.
Hey, listen, I could go through case line and verse. The contract was clear. The property was offered 15 times pursuant to the contract. There was an attempt to modify the contract.
We don't need the detail. We don't need the detail.
Well, I don't know if
I wanted, do we have the right to know if you're filing a lawsuit or not?
A lawsuit, yes. This was just an interpretation. This was seeking the court. Heather, you can explain better than I can, but it was seeking a determination as to what the status was of the matter, because the property was tainted. The notice of claim was served, which taints the property, taints the title of the property.
Right.
Okay? And unless we got that removed, we couldn't do anything. I waited 6 months from the date of the 58 hearing, which I read, which is it's an incredible read, if anybody wants to read it, until December, Paul.
I understand.
waited 6 months. They didn't do anything.
Okay, 1 minute, excuse me, wait. I want to call on council. Can you explain the Putnam County Code 11-2?
Sure. And I just have to preface by saying, with all due respect, everything Senior Deputy County Attorney Abisi said is incorrect. The county attorney does not have the authority, under any circumstances, to initiate litigation. There's crystal clear case law that in the county law where it says that the county attorney may prosecute or defend, the appellate division has routinely upheld that prosecute does not mean initiate, and that only the legislature or the Board of Supervisors can initiate legislation. Further, there's case law that says a county executive can only authorize legislation when the charter authorizes the county executive. Our charter does not authorize the county executive to file litigation. The code is crystal clear. The code says that the county attorney shall not have the power to institute any proceeding on behalf of the county, and there's 2 exceptions: when it's a judgment for money under $10,000, or whether it's directed to do so by an officer, board, or commission having the power or authority under statute. The county executive does not have the power under statute or the charter to do it. The county attorney doesn't have the power to do it. There's absolutely no authority. Prosecute and defend does not mean initiate, and I can give you the citations if you want. And so it's crystal clear. This was a proceeding. First of all, the statute speaks to a proceeding, not litigation. Ms. Abisi, you just said it's a special proceeding. So the county brought a proceeding in violation of 11-2 of the code. It's really that simple.
It actually isn't that
It's
simple.
not that simple, Rob.
All right.
Most respectfully, and it's not crystal clear either. Most respectfully.
I'll give you my case in
Most
argument, you
respectfully.
can give me yours.
I know.
Yeah,
Go ahead.
okay.
So,
Yes.
just for full disclosure, Heather, you were the outside counsel on this case before you were county
Yes,
employee.
yes.
Number one, so it wasn't like you just inherited the case from Conrad.
I know, Connor.
Connor and I have been dealing with it
Connor.
long before she
Connor.
came into the case.
Right, so you were on the case before. And secondly, I take offense to your statement that you circumvented the legislature because of any perceived conflict. That is really an assumption on your part and speculation, and is certainly not concrete.
It's not an assumption,
It is.
there is a potential
We're
conflict. We are held to a
independent thinkers,
standard
and there's
that
9
is,
of us here.
there is a standard that is the appearance of impropriety. That's the standard that we're held to. And so in order to avoid the appearance of impropriety, Mr. Spain sought the approval of the county
There's no
executive.
communication with us whatsoever.
I can't speak to the communication, that wasn't my role. My role, it was, the county attorney's role to provide those documents and lists.
That's just speculation on your part, because there is no, I don't see any perceived conflict of interest with 8 independent thinkers. Then nothing would have been compromised. You took liberty to assume that.
There was a lot of misunderstanding here, and a lot of it happened prior to me coming in. There was a lot of misunderstanding as to what was going on here. To me, the contract was crystal clear, and, again, you don't want to go through every step. I won't go through every step. It's on the top of my head, every single, thing that went on along this way, because I was involved in it right along. I think where we stand here today, I think should almost be applauded. That it's clear, whatever you want to do with the property, you can do.
That's not the issue.
My question is, why wasn't it on any of the litigation reports?
Well, John's been doing that, I can't, Paul, we did discuss it here, though, I discussed it with you.
But it wasn't on any, I read the reports, I follow what's going on, whether it's on a monthly basis, whenever they come in, I review them. If it's not there, I don't know it exists. And I'm wondering, are there any other cases that are out there?
Listen, if we're gonna commence litigation, actual litigation, I would certainly notify you,
There was actual litigation.
There was a notice of claim filed, there wasn't litigation. Notice of claim differs from serving the summons and complaint. And a matter of fact, they were giving.
We initiated it, and I was always under the impression that you couldn't initiate a proceeding without our approval.
It was responsive to a notice of claim that had been filed against us. So we were actually defending based on the notice of claim in order to prevent.
That's a notice of
But
claim.
nobody
That's
told
not a
us.
lawsuit.
Nobody told us about it.
I was told that he had been in contact.
Connor said he reached out to Rob.
I have to address that. I can tell you exactly.
Connor said he reached out to you, and you didn't want to have anything. And
That's
Paul, I brought
absolutely
it up
not
here when
true.
you were here. Paul, when you were here with Kevin even says, if you have Kevin Byrd come in, he'll even say that it was brought up here and we were told this.
Through the chair, I was contacted by Deputy County Attorney McKiernan in preparation for the 50H hearing. I spoke with him on July 10th. First of all, he asked for documents. We produced all the documents that the legislature had a day later after they were requested on May 18th. Then I was contacted on July 10th by Connor to set up a phone conversation so that I could go over with him certain conversations that had happened between an attorney and the legislature. I had that discussion with him on July 10th. The 50H hearing was on July 11th.
July 16th.
No, it was actually, I'll show you the transcript, it was July 11th. I never heard from anyone in the law department about this matter after I spoke with the senior deputy county attorney on July 10th. And I never said, don't tell me about this, I don't want to know about it. As a matter of fact, my words to him were, anything I can do to help, please let me know.
Okay, let's jump ahead. What was done wrong here? What was done wrong? You tell me what was done wrong.
You violated the charter.
Okay. Aside from that, the denouement of the matter, what was done wrong here? What are you upset with?
We didn't know about it.
Again, it's not the case per se. We're talking about the fundamentals of policy and procedure which were violated. So it begs the question, how many other things slip through the cracks? And if you're not upholding the charter as the law department, who is the prime example of those following the law and policies and procedures, and we have work that's done in a sloppy manner, it begs the question.
Sloppy manner?
Well, why in not 7 months of not having a report
It was
How?
on the, it
You
was
could be
on the,
remiss
it was.
once or
it-
twice.
My understanding is it was actually on the report, it just
Was
wasn't
not.
stating what we
7
were
months it
doing.
wasn't, no.
There was
Was
We
nothing.
got a
not.
report in the last couple of weeks
No.
where it
Six.
mentions the decision of May 6th.
Mm-hmm.
That's the only thing I saw.
Right.
Well,
With
we
seven,
have it
seven,
documented.
Legislative Sage, you had your hand up.
The only thing, I don't need to know the details of the cases. What I want to see is the litigation report. And I want to see all litigation, not just what has gotten a change, but all litigation. Because sometimes if litigation hasn't seen any activity, we still want to see it on here. We still want to understand what litigation the county is involved in. And really, that's the bottom line for this. It's not the particulars of a specific case. It's the fact that the legislature's not apprised of what litigation the county is coming down the pipe. What are we involved in? And that's what we want to know.
As I said, I don't do the reports, I can't talk
I mean,
to
that's
the
just, I would
reports.
talk to the
I
county
would
attorney.
always
Well,
come and
Because he's
explain
responsible for the
anything
reporting
to
that
the
comes down to the
legislature.
legislature.
We had a meeting, John Cherico was placed by me in charge of it. I thought he was doing a good job, I hadn't heard anything since we had the meeting, and,
That meeting, just so everybody's clear, that was the meeting you're talking about when we discussed the litigation reports.
yes, we discussed.
We
it.
discussed litigation reports, right.
There were 5 of us.
And I'll tell you, from that day forward, we've gotten the reports in a prompt way, they were punctual, they seem like they're as accurate and up to date as they can when we get them. I think that was a very productive meeting. But to say that we somehow said this case, so, just let it go. I didn't think there was anything to the case anyway, it was just.
Well, there wasn't, other than the property, the title was tainted. And the only way we could clear that up was to get a declaratory judgment from the court.
And I'm not arguing that you did the wrong thing.
No, I'm just.
I'm arguing that if you had come to us and said, this is what we need to do, you would have gotten total support, let's move forward with it. But we found out about it, it was commenced in December, we found out on May, when the decision was dropped on us on May 6th. That's all, that's all I'm saying.
Understood, as I said, I have no knowledge of what's reported or not reported, these are above my pay grade things. That I can say is that the intention here was to avoid protracted litigation or a fight of any kind. We just had the court decide what the state of the rights of the parties were, and it ended up resolving the entire matter without either side expending a lot of time, money, and, upset with respect to it.
But to the chair, we're just speaking to the fundamentals of the procedures that we follow.
Understood.
And our open and transparent communications that we have, which are dictated by our charter.
Understood.
That's the crux of the
I would just add
conversation
one
tonight.
thing, this is.
7
one-
months
this
is
is
a
one
long
of-
time.
this is
It's not
one
a
of-
loops.
This is one of a handful of matters, or more than a handful, that predated me. And I was trying to get up to speed. It was 4 months before I got there. There was a flurry of activity last December on this particular thing. There's a lot of conversation. I got a lot of calls. But, it was,
Right.
believe me,
It's
I want to know, it's been a nightmare. This
You
whole,
did a good
this whole
job.
34 Glen Ida has been a nightmare. As far as what you guys want to do with it, do whatever you want with it. I'm not saying what we should do with it or not do it. I didn't make any promises
We're
to
not
anybody.
discussing that, we're just discussing that
I
we
understand.
did follow the protocol
34
that
Glen,
should be
excuse me,
adhered
I'm gonna
to.
say, 34 Glen is on the market.
It's not on the market right at the moment, I don't believe.
Yes, but
Believe it
we
is.
voted for it to stay on the market. That's what we did. We voted to sell
I'm
the
not-
building.
we
I'm
just
just
have-
saying, that's what it
we're in the
was.
process of
It was supposed to
re-upping.
be sold, and it wasn't.
We're re-upping with the real estate entity at the moment, so I don't know. She hasn't been, authorized to proceed, who had the listing at one point, Briante, so I just know that crossed my desk the other day.
It's hard to sell a property without ingress and egress also.
Oh,
Legislative Crowley, did you have something you wanted to speak?
I wanted to know just what was the conflict of interest that stopped you guys from coming to us and asking and going to the county executive firm?
The party who was seeking to sue the county.
Yeah,
had-
on full disclosure, that's fine. You can say it's my son-in-law who wanted to
So
purchase
you
the
could
building.
have, so you could have
But-
recused
I
yourself.
did recuse
No,
myself.
I'm just, so if it was brought to, I'm asking a
Yes,
question.
I would have.
That's all I'm
Absolutely.
asking,
Yes.
that's what I'm asking.
Well, that's a
So
known
th-
fact. Of course I would have.
Okay.
Okay?
I was just-
And this has nothing to do with who it is.
I'm just
I
asking, so
understand
that
what
I
you're
never, I just wanted to see if
Yes.
that's why they went around, so
You
that it
just wanted
wasn't.
me to say who it was.
It was-
No,
So
I
didn't.
didn't,
It
I
doesn't matter.
didn't. I was
just very-
asking a question to
I
find
don't
out
wanna
why
get
they
into
went
the-
around to, for that reason, because it's never
That's
happened
not the,
before.
no, that has nothing to do with the 7 months of not being reported to us.
So that's what I was asking.
No, that has nothing to do with that.
For me, it was an extremely awkward situation. I mean, part of their request was a commission for your daughter. I mean, it was very awkward.
This has nothing to do with that, we're
Well,
talking
it
about.
does, I'm just telling you where I was coming from.
But it
in
has
terms
nothing
of
to do with it not coming to us for 7 months.
Listen, I acknowledge that.
Yeah,
Okay,
well,
we
that's
acknowledge
what we're
that, but
discussing tonight.
I'm just trying to explain to you why we were just trying to maneuver it without getting it personal, without making any names. Nothing was in the paperwork. I stripped it down, so it was strictly legal, the request to the court. They granted it, and it's over with. But there was no background, there was nothing put on who was looking for what, and so forth and so on. And I didn't feel that I should settle the case because I didn't feel the county owed the money. I do feel if the county had wanted to, we could have taken the down payment deposit because they were in default. But I didn't. We sent it back. We were trying to be fair and equitable.
Just one last, aside from the case, is it still your feeling that you can launch a proceeding or a lawsuit without coming to us?
No, listen.
He went to the county executive in the good faith belief that the statute authorized it as an alternative because it specified that there were officers that you could either go to, I can read the exact language. It says, unless directed to do so by a county board or an officer, board, commission, or body having power of authority under statute to direct the starting of such acting or proceeding, except a proceeding. So it was a good faith belief that he could seek authorization from there. It was no attempt to.
Do you still believe that the county executive has the authority to launch a lawsuit?
I mean, obviously, that's a matter of debate.
I don't think it's a matter of debate.
What I tried to say a moment ago, I was just trying to avoid personalities and anything that went on, any home cooking allegations or anything that might have gone on here, because there was a lot of irregularity in this whole thing. And I was trying to avoid making this.
I'm talking about I'm not talking about this case.
No,
I'm talking about cases in general.
I get it. Listen, next time we do a special proceeding, we'll certainly notify you.
Legislative Sage?
Thank you.
Who's to say in the future, if there's another.
Not yet. I'm sorry, excuse me. You're not notifying us, you're asking us for authority.
No, exactly. We'll notify you to come in and talk about it. Okay. I was just merely saying, we'll notify you and you'll release it here.
And just, this is one particular case, but who's to say that in the future, this couldn't happen again, and then all of a sudden you go to the county executive instead of coming to the legislature?
The only reason why we went to the county executive on this was because of the nature of the entire circumstance.
I know, but back to legislative.
I understand.
Going forward is what we're concerned about.
Next time we do a special
we all have
proceeding,
relatives
the circumstances that were
people
involved here are not going to be there, and we'll certainly bring it to you.
Yeah, that's the bottom line. It's not the specifics of the case. It's just the litigation report and coming to the legislature.
I was desperately trying to avoid any.
To avoid selling it, yes.
No, any
Yes,
any
we know
noise.
that.
Well.
Yes, we know that.
Listen, I adhered to the contract. I adhered to what the contract said. The contract didn't say parking spaces. There were a lot of people opposed to the parking spaces.
It was listed with parking, but I don't think we can discuss that tonight. We're here just to talk about. Yep, getting off track. Let's just, okay.
Thanks. Lynn Eckhart again, Town of Southeast. A quick question that's brought up in my mind because I serve on the Southeast Planning Board. What is your policy regarding conflict of interest? What constitutes one, and what do you do when you have one?
Well, I'm going to refer to our attorney.
Just through the chair, the Putnam County Ethics Code has a very thorough section on defining conflicts of interest. It defines which relatives of an employee or an official would constitute a conflict. And there's procedures in there for dealing with it. So if you really want to see the meat of it, I'd suggest you look at the code under the ethics provisions.
Okay, and then when exactly did you recuse yourself?
From the beginning.
Okay, so would that would be in minutes?
I wasn't at the
Never
meeting.
made a decision.
Excuse me?
There was never a decision made, never discussion. I wasn't a part of it.
Oh, okay.
Yeah. So when they spoke about it, I think it was in December, I wasn't at that meeting.
Okay, so I know in our meetings, when Tom LaPerche, for example, our chairman has a conflict, he actually leaves the room so that he's not party to.
Right, I was not party to anything.
Okay, so I'll read up on that, and I think in future, I would recommend that the recusal take place in public, so that the public is aware that the person who has the conflict has taken.
Oh, it would be, it would have, if I was at the meeting, it would have been.
But
I
why
was
wouldn't
ill,
it-
I was ill that night, I couldn't make it.
Okay, so it's in writing then?
That I was not here?
No, I know that.
Oh.
You put the conflict of interest in writing, so I can look at it that way.
No, I didn't, because it didn't come to that, I wasn't at this meeting when they discussed it.
Well, from then on, how did?
We never discussed it again, it never came
It was
forward.
only at one meeting? What
Yes,
meeting?
only one time.
And when was that?
December of '22, I believe.
And through the chair,
Yes.
correct me if my recollection is wrong, there was no vote taken by
Right,
the
there was no-
legislature
No, I
to
read
sell-
the- I
to
read
sell
through
this
those
property
minutes.
to the person in interest. There were 3 resolutions that, by which the legislature put this property on the market through the MLS.
Right.
There was the initial one, there was another one requiring a comparative market analysis, and then there was one requiring an appraisal, and after the appraisal came back, the legislature set the selling price. Those were the only votes that the legislature took with respect to this property. There was a meeting where the prospective purchaser came to the legislature to discuss the parking issue.
Right.
There was no vote taken
And
of
it
the
was full price
legislature.
offer also, so. it
There was, right, the
Full
contract
price.
was for the full price, but there was no vote of the legislature regarding anything to do with this individual. So had legislator Addonizio been present, then there would have been a discussion with council as to whether or not recusal was appropriate or necessary. There were no votes, and there was no recusal necessary because the legislature never voted on anything concerning this individual.
Most respectfully, though, that meeting created enormous amount of confusion. And there was nothing in those contracts calling for parking, particularly down in the sheriff's lot, which would have caused enormous
No, we're
problems
not
with
saying the
all
sheriff's
kinds
lot.
of neighbors.
But
Yeah,
but the listing had.
You're
parking.
saying something
The
that's
original-
not-
The
I don't
original
know what the
listing-
listing said, I'm just looking at the contract, the legal contract that was signed. There was nothing about parking, there was, you're throwing out things that are untrue. But that meeting that you had, that he was here, created all kinds of misrepresentations and misunderstandings that I dealt with, okay? And if you want to look at the...
There was an agreement made with the previous administration at the last minute, and
Yeah,
that
you
was
know what it looked like to me?
that was derailed at that
You
meeting.
know what it looked like to me?
Wait,
Well,
we didn't-
it looked like a lot of home cooking. There was home cooking going on. There was a lot of pressure. There was enormous pressure put on me. And I'll tell you something. Connor came to my office and said he felt threatened on several different occasions on this. Well, hey, listen,
by who?
it's easy.
Threatened by who?
Well, I don't want to start naming names, but he felt threatened on this
Well,
particular...
maybe in private you can tell me.
Pardon me?
Maybe in private you
Well,
can
if
tell
you
me.
think about who might have threatened him, it's pretty obvious, okay? You know, but I mean, you sit here and you say, oh, we just have a meeting and it was just, nothing was discussed. It created a lot of misunderstanding and misapprehensions on the part, at least on the part of him. And if you read the 58, you can see it clearly.
So to make sure I got this straight, then after that meeting in December, I read through the minutes, there were no other discussions from then on?
No.
That was it? Okay. Well, I would suggest, and you weren't at the meeting then?
No.
Okay. I would suggest in future, if it would be good to have it in writing, so that the public understands exactly what happened. It would be, I think, it would help everybody.
Through the chair, Lynn, I think it was the rules meeting of December 2022.
Yeah.
And at the last minute, there was a side agreement to the contract, which would have allowed the purchaser to buy 24 parking spaces outright. There was no appraisal with it. There was somebody had cooked up a number. I disagreed with it.
Right.
There was a lot of pressure to get it done before the end of that year, and it was derailed. I feel it was derailed at that meeting that night.
But it was a big question. I mean, reading through the minutes, it looked to be a big question because there's some people who felt it should be lease space, some people felt it should be sold. But to do something that last minute that really required a concrete answer that made sense for everyone would have been pretty rushed, in my opinion, so.
There were a lot of entities that were opposed to it. Catholic Church, VFW, the sheriff.
Madam Chairman, we're, sorry, Compton, what we're really talking about, when we need to stay on track is,
Yeah.
does the law
timeline, yeah.
department have the ability to bring litigation without authorization from the legislature?
Absolutely not. And I explained to you,
That's-
in this particular situation, why I tried to avoid it and keep it really clean and neat and not make it a huge situation like we've kind of discussed here. I didn't want any of that to come out. Nothing was ever any of the paperwork. Everything was done very, very legal, very objectively. And again,
Thank you,
if I
Lynn.
wasn't called in tonight, I wouldn't have brought up all of this. I wasn't looking to come up here and discuss any of it. Is that it?
That's it. Thank you, Heather.
Thank you, have a good night.
Thanks. Okay. Moving on to number 8, I make a motion to table at the request of legislator Montgomery. She's not able to be here. Do I have a second?
Second.
All in favor?
Aye.
And number 9 is the litigation report to look over.
Through the chair.
Yes. Let's say so.
Do we know that these are all the cases?
Well, you just asked
Well,
me.
we don't.
We don't know.
That's the crux of the conversation. that
And
we
that's
had
what
here
we
this
don't know.
evening.
And you'll never know.
So that's, I mean, I'm questioning the integrity of these reports if we don't know. So
Well,
it's,
there's no way of us knowing. Like,
and that's something that I would like to be able to understand.
And this is violation of section 1102 of the charter, if they negate the process. And that's an
Going forward,
issue.
how can we be assured that this is all the litigation, including litigation that we don't have any updates on?
Oversight, we can't.
Or assumptions that are made, and decisions made and based on assumptions.
Okay, moving on
Still don't have an
to
answer.
other business, make a motion to accept 10A. And Mike Lewis, we're gonna, do I have a second? I'm sorry.
Second.
All in favor?
Aye.
So Mike, this came in last minute from the town of Carmel. This is the ARPA and sales tax request.
Yes.
And the change for the, request for the change.
Correct. Actually, it was gonna be on time, but.
I changed my
because-
meeting, yes.
Yep, so,
Okay.
but, no, again,
Mm-hmm.
Mr. Russo's not here right now, but we worked diligently with the town of Carmel. You just get to, so that's my letter of necessity. Where's the? You just go to-
Okay, I have it here.
Yeah. So we worked diligently with this Supervisor Kazari, the town controller, Mary Ann Maxwell. They pretty much, you know, they
Water
told us.
treatment? Is that the water treatment plant?
Yes, so let me go to my other page here. So what they wanted to do is, they wanted to repurpose 1,315,630 to resurfacing and repaving, and that was a final rule, an amendment to the final rule that allows subrecipients the ability to, you know, to do repaving. So this is a really good use. The way I look at it is, you know, it's gonna benefit the town, but ultimately, it's, you know, it's in the county. So, and this is a good way to really get these funds, you know, spent, committed. As we all know, the paving season is starting. So, and on this, let's see here, I also attached the paving schedule on the roads that they're looking to do.
Okay.
It was properly vetted through the ARPA consultant. Good use of funds.
Very good. Thank you. Any questions, discussion? Legislator Elner?
Yes. They're moving money into Carmel Water District 2, and in interest of full disclosure, I live in that water district, and this building is in this water district. The water treatment plant there is circa 60 years old, has served its useful life, and it's going to be a very significant expenditure. So I think the town is doing something very good for all the residents of Water District 2. So I'm absolutely in favor of this request.
Very good. Legislator Crowley?
Thank you. I'm also in favor of this. I mean, our roads are horrendous all over from state, county, town, so it's much needed, and I'm thankful for it. I'm glad we got it in before the time ran.
Yep.
Okay,
Thank
good. Anyone else from the only room left? Okay. I'll make a motion to approve. 10A, second? All in favor?
Aye.
Motion to adjourn. Have a second.
Second.
All in favor?
Aye.